day in the hallway, you're singing, "Oh, happy day."
One word prayer. Justice, where are you?
All righty. Welcome to Justice Served TV. Michael Bryant here.
Hi, Linda Kenny Bodden here. A lot going on today, Michael.
It really is. This is normally our kind of our Q&A day, so we're kind of blending this into Q&A and Daniel Penny as we've been down at the courthouse, and we're going to start kind of covering that because it's not on the TV anywhere. There's no cameras in the courtroom, so we're going to do our best.
That's because New York. Just let me advise everybody that New York doesn't have cameras in the courtroom. Not that they don't have cameras in the courtroom. They
perfectly
can have
legal.
cameras
They could do it if they wanted.
But they don't. The judges just generally don't allow it. It had to do with a case way back when called Hedda Nussbaum and killing of a child, and it's all a mess. But anyhow, here we are. I'm in New York City right now, and you are in Connecticut right now.
Yep.
But you were today in New York City. So what's happening?
So
good evening, by the way, Afton. Good evening, Afton.
Yeah, not a lot happening today, actually. Wednesdays are kind of the do other stuff day, but it's a good day for us to kind of catch up as we propel forward because there have been some interesting witnesses to testify in this case. Before we get to that, though, remember what this case is about. Okay, this is Daniel Penny, who did what he thought was appropriate at the time when Jordan Neely entered that subway car on the F train, May 1st, 2023, started yelling and screaming, and maybe threatened people on the train. That's still yet to be established. Certainly people were nervous about it, but did they feel threatened? That may be a different story, critical. But I think it's important to note that these things are not totally unusual to just, have homeless people or people somewhat drug addled show up on the subway. And why do I say that? You might be asking, hey, Michael, why do you say that? I'll tell you why. Just today, obviously, I was on my way down to the courthouse, and I, had my own little encounter. I don't know if it was, I don't know that I felt threatened, but it was definitely an odd moment. Let's take a look at some of this. Okay, this is me right across from this guy on the subway, leaning against the doors, just having a fine time. When the train came to a stop, he would just lean forward or flop over so the doors could open. And then people would crawl over and around. It was pretty crowded in the car. Everybody's pushed over to that side of the car. I'm the guy nearest to
I couldn't hear you over all the subway noise there, Michael. Repeat you.
He was he was just kind of hanging out there, smoking whatever he was smoking, and all the people in the subway car had moved over to his right, my left, and I was closest to him. I just happened to come in that spot, and so not unlike Jordan Neely, this guy clearly was somewhat, altered. So I'm watching this guy, and as time goes on, he starts taking his clothes off. And he's taking it like a shirt and then a sweater, and he's whipping it around. He's hitting it off my leg. And I wasn't sure what the plan was. I didn't know what he was doing. I don't know if I felt threatened. I certainly felt a little bit of apprehension, but nothing ever came of it. Let me show you how he ended up here after his disrobing.
This is a Brooklyn-bound 4 train. The next stop is Hilltop Street.
Stand clear of the closing doors, please.
Okay, so basically, he sidles a little bit out of the way, but mostly it's on you to get around him. Nobody said anything to him. Nobody came into contact with him either by accident or on purpose. I'm just saying that's not an unusual day on the subway. Right. Unfortunate. Right. I don't know what this guy's problem was. He was obviously smoking something, high on something, and just part of the traffic flow this morning. So,
well, we have a huge homeless population, not just here but other cities. we have a huge population that there's no mental health services for, not just here, but other cities. But yeah, I think you're going to point out the key, which is no one seemed to be felt threatened. No one put him in a chokehold, right? No one killed him.
I shut the camera off there before I put him in that chokehold. Nobody was doing that on camera. So the key in this case, obviously, is if this guy had been yelling, screaming, being much more animated, and in a way threatening, either verbally or physically, who knows? I mean, who knows how it would have changed. When the jury was selected, they were asked about their own encounters on the subway, and many of them said, yeah, they'd seen stuff like this. They either did or did not feel threatened. And now we've had the witnesses testify about the encounter that day with Jordan Neely and watching what played out between Jordan Neely and Daniel Penny. A couple of folks. One was an 18-year-old girl, and she said, "I just want to get out." We have the benefit here of some of the the lovely artwork. I think if I can find it here. Let's see. This woman is, I think this is the 18-year-old. So she's basically showing the jury on that board where she was in the subway, and where Neely was in the subway, and where Daniel Penny was. She did say that she felt that Neely was the aggressor. She said that. That's going to be key. And obviously the prosecution wants to address that somewhat head on. That they aren't going into this saying only a fool would feel threatened. I think that would be a bad play. So they have decided, to at least tell the full story in terms of this particular witness, that she did feel, like, hey, it wasn't fun. I wanted to get the hell out of there.
Yeah. And then he's on trial, Daniel Penny, let's remind everybody, for 2 counts. One is manslaughter, and the second count is criminal negligence. And really, if you think about a civil case, manslaughter is nothing but recklessness in New York, if you were reckless conduct. And criminal negligence is exactly what it sounds, negligence, but it's criminal. So a big difference in penalties here. And you have a pet peeve about the penalties, right?
Well, it's 15 years for manslaughter. It's 4 years for the criminally negligent homicide. They don't lump together. It's one or the other. It's an alternate pleading situation. Sometimes people reporting on it get a little lazy, and they say he could, be sentenced to 19 years. No, he can't. One thing about this, again, this witness's name is Yvette, I believe. 18 at the time, 19 now. And she said even though that Neely was yelling, he didn't touch anybody, and he didn't seem to be yelling at anybody in particular. Just kind of, ranting. So the other witness who was much more involved, his name was Mr. Goodson, Larry Goodson. This guy actually was trying to, I don't know if assist is the right word, but he was involved more with actually, touching the victim. And here he is, he's testifying to what, the chokehold, and he was trying to move Penny's arm and had told him, hey, you're going to choke him out. He basically was saying, if I hold his legs here, you can release your chokehold. At some point, Neely defecated on himself and wet himself, which clued this witness into maybe, Penny, maybe you're, kind of going overboard here.
And maybe he was dying at that point. That's the
well, there was also a point at which he went still. He went
Right.
still. So, I know this starts to smell a lot like, the George Floyd case. For those reasons, it becomes maybe sometimes not so much about doing it, but doing it too long. At a certain point, whatever was reasonable becomes unreasonable.
Right.
And obviously that's what the prosecution is going to be arguing, is that, even if he was being a good Samaritan, a hero initially, at a certain point, so we talked about the other day. You
become a savior. You have that savior syndrome, as it's called, or whatever, right? And you go overboard.
When we saw some of the body cam the other day, we heard Penny say to the cops, they asked him, did they have a weapon? And he said, I don't know. I just put him out. So, and again, then the EMTs found a pulse. So there's going to be an argument that, hey, well, he didn't kill the guy. He disabled the guy to help the passengers and himself. So that's where that case is. Oh, let's see. Those are lovely artist drawings, right?
Right.
Look at this baby. Look at that.
Can you zoom it back in now? Because court was not in session, you had a chance to go to the actual courtroom, which is on the 13th floor of Center Street, of 100 Center Street,
Yes.
and be able to get in there and make that. I think you should sign it, because that may be artwork that I can give to some organization. We can auction it off for the benefit of everybody. Maybe in the future that'll be something that we give on instead of a copy, you'll get Michael Brian's artwork. Explain that to us.
So, basically I'm trying to suggest the well of the court, which is this area here where the bench is, the witness stand, the jury, the attorneys. Not much different in terms of size than a lot of courtrooms, but the gallery area here, big. It's very big. And I've been told, I was talking to one of the bailiffs. I think she's the head bailiff. Her name is Person. That's her name, Person.
First or last?
That's her first name, Person. So she said that, that people are queuing up quite early to get into those seats, to these pews. And then they do the same thing in the afternoon. If you got there in the morning early enough to get a seat, too bad. It doesn't carry over into the afternoon. You still got to queue up again in the afternoon.
No, there's no overflow room, right? There's no overflow room.
No,
for
and they've
people,
decided
right?
no overflow, which I think is interesting. Why would you just? I mean, I guess they just don't have the room. But that's unfortunate, and it also could be that they're very close in terms of the capacity versus demand. It's, if they only have to shut 2 or 3 people out, they're not going to do an overflow. So all the usual folks are there. Daily Mail and New York Post and all the print media is there. The local folks are there as well.
And us, we have a badge. Show your badge. We have a press badge.
We don't need no stinking badges. Where did I put my badge? Yeah. So we're there. We are. We're official. There you go.
City of New York.
So yeah, and I'm telling you right now, it was easier to get a passport than that thing. So back tomorrow, and we'll see what unfolds in that courtroom. I think I thought I had one more note on this case.
And you're going to be back tomorrow, and we're thinking of actually running another question and answer tomorrow night, right? Live, to let them know what's happening.
Yeah, or a follow-up in this case combined with whatever else.
Right, 7 o'clock, maybe 7 o'clock tomorrow night to give you time to get back.
I think that would be better, just to give me a little extra time before.
By the way, that's 2B, the poodle you're hearing in the background.
There is, we are kind of combining Q&A with other stuff. And we talked about the alternate pleading concept, right?
Right.
We have a question about that, as I recall. Let's see if we get this out here. And again, it's pending currently on trial, blah, blah, blah. Don't those accusations contradict each other? So that's why it's confusing when people say, well, how can he be guilty of both manslaughter and criminally negligent homicide? You can't be.
Can't be.
It's just to give the jury an option either way. And that's smart. I mean, that's just normal pleading, right?
Right. Normally, in many states, you don't indict for the two. You have a lesser included. But there is an argument, and it's been made in many other states, that negligent homicide is really not a lesser included of recklessness. So kind of an interesting, New York avoids it by just indicting for both. Yeah.
And there may even be something lesser included when they get to the actual verdict form.
Could be assault, right? It could be assault.
It could be a simple assault. Yeah. So, and that, of course, will be up to the attorneys to hammer out and see what the judge will allow them to say or not say.
Right.
Okay. So,
how long, Michael? How long do you think this trial is going to go?
Well, the original estimate was 6 weeks. I don't know. I mean, it seems to me they got the jury quicker than expected. We're now, technically tomorrow will only be day 4 because of the. They only do 4 days a week anyhow. So tomorrow will be day 4. I'm trying to I asked Person if they'd had an updated, estimate, but this early in the trial, not really able to fine tune it much more than that. I'll see if I can learn going into tomorrow whether or not they've got a new estimate. But I would say 6 weeks for sure.
6 weeks. We have a question here. S, let's go. P, has there really no New York court broadcast? You have a right to see it. Now, they can broadcast. New York does have the ability to have cameras, but every judge has the ability to say yes or no, and they just don't do it. You remember in the Trump trial, which happened on the 15th floor, right above where you are on the 13th floor, the judge did let still cameras in for a moment, both I think in the morning before they actually started, if I recall, Michael.
And a
to take
little
some
bit of
pictures.
video, very little video.
Right, right, and very little bit of video, and then they were out. They just don't do it after that, and you can all Google it. It was a case way back when, and I think one of the attorneys at least was Barry Scheck on the case I mentioned earlier. Right.
I do think it's funny that they seem to be in lockstep about not letting cameras in. I mean, it's almost like nobody is willing to break that line,
Right,
the judicial line that everybody seems to have drawn. They must have had a meeting or something. Something's going on behind the scenes. It's just too weird that they would all say no. It's just too weird.
Right. Now you can Google, for those watching, they had a newsbound case. Joel Steinberg had a newsbound. That was the last time there were cameras in the courtroom, and that led kind of like OJ when it was in California, just a little bit of his court history. That kind of led to no cameras in the courtroom. Just like in New Jersey, there was a case back in 1930s called Charles Lindbergh, and that led to no cameras in New Jersey for years upon years upon years. And the same with this Joel Steinberg had a newspaper, and that's why both also in O.J. Simpson, for those of you, because I know you all love the courtroom aspect in California, you can't show the people now in the courtroom after O.J.
Gallery,
Simpson. The gallery. They don't want people like, oh my God.
The Menendez case also contributed to that, but obviously you can still show cases. We did a case. It ended up being kind of a dud, but it was the Wes Merritt. I think it was Merritt was the guy's name. He was accused of killing his wife and maybe a kid was in the desert.
Right.
But that was like a 3 or 4 month trial, and that was televised. So in San Bernardino County, I think it was.
Yeah.
Anyway, so it's unfortunate. So we're doing the best we can to at least bring it somewhat to life. Hey, with stuff like that, come on.
All right. So maybe that'll eventually be one of the prizes for where in the world are you?
Yeah, right.
Justice.
Somebody's dying for that. Okay, no. Let's see.
This is Tubi who's yelling. This is Tubi who's yelling at me. Can you all hear that? Like put your hands up if you hear him screaming at me, because he would like to play. Just so you know.
Okay, so let's move on to that other trial that we've been looking at, YSL. If you're ready to, can we move on to that?
Yeah, absolutely.
This question is from Zuam08. Can the state read this? And by this, I think they mean the most recent plea deal, which ultimately was the non-negotiated plea, Jeffrey Williams. Can they read this into the record in the trial against the rest of the defendants now that it's been signed, like to let the jury know why he was gone from the trial? Well, that ain't going to happen. No, that is not going to happen.
Yeah, no, that's not going to happen. As a matter of fact, there's a question that came up because the prosecution again showed all this jewelry, right? When we started back with Yak Gotti and Shannon Stillwell, and they say, wait a second, the jewelry, the guns, wait, didn't Doug plead guilty to that? Or no, one of those counts? So why now we're showing it against, to say possession against these two when he's already pleaded guilty to that? So, it seems kind of unfair, doesn't it?
Yeah, there's no doubt about it. Let me see what else we got here.
Yes, my Tubi does want screen time. Tubi's a very beautiful show poodle, just so you know. And he's also very animated, as you can see. He's kind of like pod partner here. So
is he around somewhere? I can't.
Yeah, he's around, but he's not where I can reach him. He's staying out of his mother can grab him, put him on her lap, and quiet him down.
Okay, let me find. We'll stick with YSL here. Let's see. I got another little something. Try this one. This is from Alleyfly 7873. Does continued sloppiness by the state become intentional in the law? Interesting question. As a matter of law, is sloppiness translated to intentional? I don't think that's going to happen. What do you think?
No, it's not going to happen. But the question becomes, if you do it over and over and over and over and over and over again, does it become something that but more than sloppy. And that's what I think Doug Weinstein, our friend Doug, who we haven't had on since he's taken lead counsel, we hope to have on because so many things happened in that courtroom this last week. That's why he wants a mistrial with prejudice, because he said at some point it just can't be sloppy. It just can't be sloppy. And so far the judges said it's just sloppy.
Yep. So far. We'll see how long that lasts. Okay, I think I got another YSL here. Stand by. I just did that one. This is interesting. He says, Afton. Look at that.
Afton, there you are, Afton.
Afton's. Found it interesting that the judge gave fewer restrictions than Steele proposed. What do you think about that? I think it speaks well of the judge because she's been watching this case. And she knows a little of the history, not as much as Glanville may have known, but she takes it on herself to basically make it a little less onerous on Jeffrey Williams for his probation than even Steele mentioned.
Right, because Steele mentioned giving him house arrest. I think after it was for 3 years, if I recall, putting him on house arrest with a bracelet, and then she felt no need to do that, which is really interesting. And I think that's why when Jeffrey Williams pleaded, he pled guilty to the several counts and to the NOLO on the 2 counts. He said, "Thank you for instilling fairness," and his voice just crackled in there when he said that. Fairness into this trial. Hint, hint, Judge Glanville. Hint, hint, hint. More than hint, hint. It's very interesting. I guess she had an opportunity to watch him and feel that he was not going to, he was not the threat the prosecution was saying that he was. And I think he already started some of his community service today, Michael.
Really?
Brian Steele had him on like a power cell phone for FaceTime in a class at Emory today, where he was talking to the students in law school about his trial and about gangs and all. So I think that's probably started towards his community service that he has to fulfill.
Yeah, interesting. I remember I had a moot court competition at Emory. I do remember that. Of course, kicked their asses. But hey, that's a different story. Okay, so look at this. Vicky Lee 7866. Imperfect people cannot administer perfect justice. So just a Zen comment.
So true.
Yes, deep.
Yeah.
It's very deep.
Yeah, it's very deep. It's also. Let me add to this. I think that prosecutors who, and I have this problem with prosecutors who are elected, who use it as a stepping stone to further public office, really cannot administer perfect justice. Yes, of course, many of them are looking out for their constituents and looking out to make sure the streets are safe. But there are those, and we've seen them, who then run for attorney general, the Senate, different type of things, House of Representatives. And you have to wonder when they're making those decisions, are they making the decisions in the best interest of their constituents or in their own political best interest? And that's the problem I have with elected prosecutors.
Okay, so we're going to move on here to, how about Karen Reed? Busy day in Karen Reed today, right?
Right, another case, right.
I mean, obviously Karen Reed we're familiar with from Massachusetts, the Commonwealth versus Karen Reed. First thing that they did was, as we know, there were allegedly a number of jurors, in fact, all of them, that found her not guilty on counts 1 and count 3. That's now up on appeal because it was never made known to anybody because the court never questioned the jury further when the mistrial was declared. So the arguments were made at the appellate level. We'll see what happens. But perhaps connected with this wait for the appeal to be decided is the fact that both the prosecution and the defense have asked to push the trial from its late January current trial date to April. What do you think about that?
Okay, so what could be happening here? Maybe they both want to wait for the top court in Massachusetts to issue the opinion about whether the jury has found her not guilty on the murder counts, right? That's a possibility. Second possibility is, hey, it's right after Christmas and no one really wants to get ready for a trial over the Christmas holidays for January. That's a possibility. And they all have other things to do. Third possibility I can think of is maybe they're working out some type of plea arrangement. That's a possibility. A lot of possibilities here. What do you all think?
Yeah, I think the best guess, just logically, is the appeal. Because if the appellate court comes down and says, yeah, we need to bring the jury, and that's what would happen if the appellate court decides that this claim that counts 1 and count 1 and 3 were actually decided not guilty by this jury. What do you do? How do you fix that? They're going to bring that jury back in,
Right.
and question them. Well, if you've already had a second trial, does it become moot, or is it going to be during, right at or about the time of the trial? You're smack in the middle of it. It's just, it just gets messy. So it makes sense to me. I mean, a plea deal is not out of the question, but I think it would be connected with the appeal of those number 1 and 3 counts, because if the prosecution says, look, we couldn't convince one jury, maybe we aren't going to win those. Let's try and work out a deal on the second count and make this thing go away. So a plea is possible. I think more likely it's just the clunkiness of having the appeal pending on really the 2 top charges against Karen Reed. So
Afton points out, and rightly so, in Massachusetts, the foreperson is chosen by the judge. Now, when we tried Hernandez, when the foreperson was chosen by the judge, we objected strenuously on the basis that that really is kind of like the judge is doing the foreperson, right? The judge. I mean, couldn't that be discriminatory? Couldn't it be the judge thinks that's the person that's going to side for a guilty verdict? Whatever. We thought but it's in their law, and it's one of the few states that happens in, Michael. So why don't we go to S, let's go P, Super Chatter. I've heard that one juror wrote a letter about bias and another may have heard about the pleas. How can this continue? This is going back to YSL.
Yeah.
So let's jump back to YSL for a moment. Go ahead, Michael.
Yeah, well, we heard it was an email, actually, that was sent to the clerk and said, hey, could you pass this on to the judge? And it basically said, actually 2 emails were sent. One was, it's like the juror sent a draft and then changed it and sent the second version, which was basically the same, which said that I hate the state. Those are my words. Whatever the state says, I don't believe, and I can't serve any longer on this jury.
Yeah, so, I'm biased, right?
Yeah, I'm biased.
Absolutely.
I can't. Yeah. I'm telling you right now.
But the judge had a great response. The judge said to the prosecutor, well, if they're biased against you brought this upon yourselves. I'm not dismissing the juror.
Yeah,
right?
You got to convince them, that person, that you got a righteous case here.
And Doug Weinstein is just sitting there, looking like, I thought it was great. And yet after that, sitting, but now we go. She heard that a second juror wants out. Well, they may be wanting out because now they know Jeffrey Williams has pleaded nolo and he's out, and it's why waste our time. But today, Michael, they did say that the state plans to rest now
in 2 weeks. Yeah,
in 2 weeks, not in 2025, not in 2026. Oh dear me! And the judge said the case will be over by the holidays.
Yeah.
So.
That would be great. And the second part of S, let's go P question.
Right, I'm going to put it back that up.
That at least one juror heard about a plea. I think that's probably universal. I'd be shocked if they all have not heard about a plea, all the pleas, the Jeffrey Williams plea. I just, I'm not that naive. I think they've heard about it. How's that going to affect them? This is one of those deals where the court says, well, you have to ignore those things. You have to ignore the fact that we've changed the furniture because there's only 2 defendants left. Just put that out of your mind.
Yeah. And then the questioning was like, well, what did you hear when they're in the other room? And you remember we talked about a juror being in the kitchen and then they hear their family in the other room or vice versa. That's exactly what the questioning went. Well, I happen to be in the kitchen and I hear them in the other room. Well, what did you hear? Will it make a difference to you if you heard that somebody pleaded guilty? Would this make a difference? Can you put it out of your mind? It was perfect.
That's what would happen if that nugget became the court became aware of that. The court would then question that juror. What did you hear? How did it happen? Because they want to know if it was intentional
and they did.
Accidental.
Yeah,
and if it was intentional, then you got a bigger issue because then
right.
the juror is seeking out the information, which is totally forbidden. But if they just heard it walking down the street, they're on the subway, and relatives in the kitchen, whatever it was, more innocent, then the
Yeah.
court's just going to say, "Can you put that out of your mind?" And then the
Yeah,
juror will say,
and
"No,
that's what
I can't."
that's what Judge Page Whitaker did, right? You put it out of their mind. The jury said, "Yeah, no problem here." I'm not saying you did anything wrong, says the judge. You put it out of your mind, no problem. I can put it out of your mind. So I think that Doug is standing there, and Max Sharp is standing there at this point, saying to myself, "Well, maybe we made the right decision going for,
Well, it
trying to
makes you
get a not
think.
guilty."
Right now, as it stands, unless Mr. I Hate the State or Ms. I Hate the State, I think it was a guy, but don't quote me on that. It was a guy or a girl. They basically have a hung jury as it sits right now. Worst case scenario, if that person sticks to their I Hate the State position, you got a hung jury.
Right. So really interesting. And then then remember, Doug has like 30 days to come back in and ask for his plea to be recanted. All the people have like 30 days or something, if I recall. Whether that would happen, I doubt it. Because,
Oh my gosh.
wouldn't that be a novel, so to speak? But
that would be a
all right.
total mess. Yeah.
Okay, so let's go now. Let's go back to where we were. Karen Reed, that was a great question. S, let's go, P. Thank you very much.
I think I have one more Karen Reedish quote. Oh, this is interesting. Remember, just recently she did a huge article for Vanity Fair, an interview. I think it was even 2 parts. And so it was pretty elaborate. And this question references, what someone can or can't do in the context of a criminal proceeding. And I know what they're alluding to is the son of Sam rule. But
Right.
remember, that we don't have a conviction here. She's just a innocent until proven guilty. So she can, this was bling bling Brit. She cannot make money for this. There are laws against making money. She did the interview for free. I don't know if she did the interview for free or not. Vanity Fair could go either way. They can write the check or they could just do the interview. But it doesn't matter. She's not convicted.
Right.
So yes, she can make money off of it.
Right. And also, the game is that your attorney provides photographs, and the attorney gets money, and it then goes to the attorney before there's a conviction, right? Licensing of photographs, and also, people do interviews for free because it's a way of between trials of getting your case out there. The lawyer's not doing the interviews, so the lawyer's not violating any rules of ethics, but it's a First Amendment right for you as a defendant, as long as there's no gag order that says you cannot do this, to be able to speak freely to the press, and there's none.
Yep. So, if they extend the trial into April, maybe she'll do some more interviews. Who knows?
Hi, Karen Reed. Here we are.
Yeah, pop on over. Yeah, she's not shy about that. That is for sure.
Yeah. Anything else that you had on Reed?
Let's
Because
see if
we
I have-
had.
I think that was it on Reed.
Yeah, so we had three things on Reed. We've got the Supreme Court argument, we've got the motion for the stay, and today also, by the way, the Commonwealth filed a motion for the defense to produce, not the defense actually, for something called Metro, which is part of what we understand T-Mobile, to produce all sorts of video recordings and all sorts of things today that just got filed before we got on the air. I haven't had a chance to look at it. So a lot of stuff was happening in Karen Reed today.
Yeah, so it'll be very interesting. I mean, is there any doubt they're going to move the trial date? I think that's a given. When you have both sides agreeing, and they say they're doing it to prepare. Again, our guesstimates are it's maybe more connected to the appeal. But yeah, they both go in and say court, and again, they're not. July was the ruling on the mistrial, right? So you have to retry within a year. So even if they push it to April, they're still fine.
Well, start the retrial, I think it is, which is kind of interesting. You don't have to finish. Right?
No, you don't have to finish. No, that would be bad. No, you just have to.
I'd make that argument.
Pick the jury.
I'd make that argument. All right, so I think that's it. Anybody have any other questions before we go? Because we'll be back tomorrow night after Michael is in the Daniel Penny case, where he will be in that courtroom tomorrow, traveling back to New York so he can report on it. Since there are no cameras in the courtroom, he is the camera. He's going to be the Brian and Baden Justice Serve TV camera.
You know what I think is interesting? It is they have no fear of trichodecaphobia there. I mean, it's not just on the 13th floor.
What?
Trichodecaphobia. That's fear of the number 13. It's not just on the 13th floor. It's courtroom 1313. So I don't know what that means, but in New York,
that means it was built. That was mean the courthouse was built before the Depression, because it was after the Depression that you don't have 13 floors.
I didn't know that. Why would that be?
Yes, because of they were superstitious about people jumping off buildings and all. So if you have all your modern buildings don't have a 13th floor, all your pre-Depression buildings have a 13th floor.
But why would the Depression affect whether people are
It was superstition.
uncomfortable with it? I mean, but the number 13 has been around forever.
Yeah, but it's superstition. You know, at 13,
know.
you know, Stephen King. Stephen, let me give you a piece of trivia, all in case you're ever right. That and 13's unlucky. So Stephen King does not stay in a room. If he's in a hotel room, will not stay in a room that's either ends in 13 or the numbers add up to 13. Just so you know, a little piece of trivia if you're on Jeopardy. If they ask you what author doesn't stay in a room that has ends in
Stephen
13,
King?
who is Stephen King? There you go. You'd win. You'd win, and you wouldn't have to worry about quoting Dorothy Parker and women with glasses.
All right.
Okay.
I think that's I can't top that. Okay. I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kenny Bodden. And subscribe, like, share, notify, and we'll see you soon.